couple days ago, the Supreme Court came out with a decision essentially rewriting employment law in the United States. The Democrats had been trying to do this with the so-called Equality Act, but it had not gotten through Congress. So Justice Gorsuch and a 6-3 majority of the Supreme Court decided, hey, why not do it ourselves? And we'll just rewrite the Civil Rights Act of 1964 to pretend that the Civil Rights Act of 1964 included sexual orientation and transgenderism, concepts in the case of sexual orientation that clearly were not included, or in the case of gender identity that nobody had ever heard of because it's crazy. Joining us on the line to discuss is Ryan Anderson. He is the William Simon Research Fellow at the Heritage Foundation and founder and editor of Public Discourse. He's also the author of When Harry Became Sally, Responding to the Transgender Moment. Ryan, thanks so much for joining the show. Appreciate it.
Happy to be with you.
So what do you think are the consequences of this decision? So, we can put aside the fact that I think it's pretty obvious that this is a bad legal decision, that the Civil Rights Act did not mean to encompass sexual orientation. People knew about gays and lesbians back in 1964, and it certainly did not mean to encompass men who believe they are women, because it seems that Title VII is now in direct conflict with Title IX. Title IX protects biological women, and apparently Title VII now requires biological men to be treated as biological women if they so demand, which is bizarre. What are the actual ramifications of this decision for employers in the United States?
Yeah, I think you're going to see the collision you just mentioned between Title VII and Title IX. I think that's going to be answered by saying that Title IX, when it bans discrimination on the basis of sex, that means, according to Gorsuch, a man who identifies as a woman, if you don't treat him as if he's a woman, you're discriminating against him on the basis of his sex. Because Gorsuch's logic here is that if two people identify as women, one of whom is female and one of whom is male, and if you treat them differently, you're discriminating against them on the basis of their sex. So this will have impacts not just in employment law, but I very soon expect to see some lawyers on the left file a lawsuit to get this applied to education law via Title IX. And then we'll see what it means for bathrooms, for locker rooms, for sports teams, athletic competitions. It's going to have a whole host of consequences in the workplace. Pronouns. You know about hostile workplace doctrine. So if you are an employer and someone refuses to use the preferred pronouns, that could foster a hostile workplace. And you as the employer will now have a legal duty to make that employee use the preferred pronouns or to get rid of that employee. Right? There are going to be all sorts of litigation that follows from this because, as you said, the court just rewrote the law.
I mean, that last point is such a telling one, because the entire logic of the court is that transgenderism is protected under sex discrimination because you're discriminating against a biological male because he's a biological male if he says that he is a woman, correct? So you're discriminating against him as a man, not as a woman. You're discriminating against him as a man. But if you say that he's a man, you may be violating law now.
That is exactly right. That is the logic. I mean, there's a simplistic logic to Gorsuch's opinion where he says, if the employee, or by extension, the student, would have been treated different if the employee or student were a different sex, that's an instance of discrimination on the basis of sex, right? So what he's read into the law is androgyny, right? He's read into the law that we can take no account of the biological differences between men and women, boys or girls. Otherwise, we're discriminating on the basis of their sex. And that's not what Title VII or Title IX required. It said you can't have double standards. It didn't say you can't have any standards at all.
So the real question for religious institutions is obviously how the Supreme Court draws the lines there, because where we're going to see the most conflict, aside from the free speech issues. I mean, first of all, it seems to me entirely bizarre that free speech doctrine would allow laws that prevent me from saying a biological fact. Like that's an incredible, incredible thing. The idea that free speech doctrine would would force me to be fired or create legal liability on the basis that I have said something that is a biological fact. I mean, I guess maybe the Supreme Court upholds that idea, that if I say that a transgender male is in fact a woman, that I can now be I must be fired from my job or disciplined in some way, that is now federal law, does not violate the First Amendment. Like how that is possible is beyond me, but the Supreme Court is rewriting laws as they go. I wonder how close that comes to hate speech legislation in effect.
So I don't know how that would intersect with hate speech, but I think the way that they're going to do it with preferred pronouns is they would say, all right, you as a radio show host have a First Amendment right to say that person X, Y, and Z is a male or is a female, but you have to use the preferred pronouns because that's not asserting anything. That's just a way of avoiding a hostile work environment. There's a case at the Sixth Circuit right now involving a professor who wasn't going to use preferred pronouns. He got fired. We're going to see how the Sixth Circuit handles that case, and it might get to the Supreme Court. There are two cases that we're waiting to hear answers from the Supreme Court this term. So, within the next 2 weeks, we're going to hear two ministerial exception cases. These are particularly Catholic school teachers who've been dismissed from their job. And the court's going to tell us how broad or how narrow who constitutes a minister is. And that's going to determine the religious liberty part of this, right? How will we be able to make employment decisions at religious institutions? But the question you also raise is, you could be a religious person working in a secular business, right? Hosting a secular radio show, right? What are your freedoms going to be? What sort of liability are you going to have? And I don't see a clear answer to that coming anytime soon from the court.
When it comes to the religious liberty question, and the real question, as you mentioned, is the fact that if you're a secular worker at a religious institution. So I went to Jewish day school. We had our Hebrew studies in the morning, and then we had our secular subjects in the afternoon. The secular teachers were secular. They were science teachers, but there I'm sure were behavioral requirements that were placed upon them so that they were not promulgating anti-religious messages in the classroom. For example, you could see that completely overturned. You could see the Catholic Church forced to employ transgender people or to pay for transgender surgery in their insurance coverage. So we would relitigate, presumably, Little Sisters of the Poor. And all this could get very ugly very quickly.
Oh, very much so, because depending on how they say who constitutes a minister for the purpose of the ministerial exemption, it could be just teachers who teach religion, or it could be all teachers who are meant to embody the truths of the religion, right? I mean, there are two ways in which you teach people about religion. One is by teaching them stuff at the chalkboard. The other is by living your life in accordance with the sacred dogmas, the sacred teachings of your religious community. And we shouldn't just think that ministering or teaching only takes place with kind of the verbal instruction. I think we learn a lot more by example, right? But the court's going to answer that, either correctly or incorrectly. Healthcare plans, another big case last week. Trump's HHS finally, 3.5 years later, fixed a bad Obamacare mandate that would have mandated coverage of sex reassignment procedures, would have mandated hospitals and doctors perform these procedures. It's unclear now what the law is going to be on this in light of the Title VII ruling, because if you apply the same logic consistently, it's going to suggest a bad outcome here, right? The court isn't always consistent, right?
And so there's been some talk about the possibility of a sort of fairness for all Utah outcome. David French has talked about this a little bit. We're talking with Professor Ryan Anderson of the Heritage Foundation. The idea that basically Gorsuch has broadened LGBTQIA employment rights, but that he is about to carve out all sorts of significant religious exceptions to that rule. I hope that's the case, but it also does backfoot virtually all religious people in the country by essentially suggesting the only reason that you're quote unquote allowed to be a bigot is because you're religious. And this is a case that you've seen from Cory Booker and Beto O'Rourke, which is that religion is actually just cover for bigotry. You can't have any good faith reason, for example, not to want your third grade child taught by a man who believes he's a woman. That the only reason that you'd want to do that is because of religious bigotry, and the only way you can get out of it is by invoking your religious bigotry. It seems that Gorsuch made a decision that is not just a decision about the interpretation of law that is faulty, but a decision about human nature itself that utterly denies the reality of sex entirely.
Oh, that's entirely correct. I mean, one is that he shouldn't be legislating from the bench. His job is to adjudicate cases. He's a judge. He's not a lawmaker. And everything you just described, especially the insights from David French, is that this is a legislative question, right? How do we balance a coercive law like a SOGI law with permissive religious liberty considerations? But then the second point is, and why should this be limited to the religious domain, right? Why should it be the general rule is you're a bigot, but you have a carve out for your bigotry in your religious enclaves? And then the third point, and what about all the secular women, right? You don't need to be religious to not want a boy in your locker room, to not have to lose a championship track race to a boy who identifies as a girl, right? Those aren't religious liberty concerns. Those are concerns about privacy, about safety, about basic fairness and equality in sports. And the question is, why is the court trying to make policy on these questions, right? Policymakers should make policy, and religious liberty isn't the only concern here. So even if David's right that this is going to be some sort of like grand compromise, Utah compromise given to us by, 9 robed justices, that still isn't a good outcome, right? So for both procedural and substantive reasons, we should be, pretty upset about what Gorsuch has done here.
Professor Ryan Anderson of the Heritage Foundation. One of the speculative ideas here was that perhaps the reason that Roberts joined on to the opinion is so he could assign it to Gorsuch as opposed to assigning it to somebody like Ginsburg. That he was going to join the decision either way, but he knew which way Gorsuch was going to vote. But if Roberts doesn't vote for it, then Roberts doesn't get to assign the opinion. It just goes to Ginsburg, and instead you get a full scale anti-religious diatribe. What do you make of that particular argument?
I mean, there's some plausibility to that. We don't know, obviously, what the chief thinks about this because he didn't write under his own name. It's interesting that there weren't any concurring opinions, right? Ginsburg didn't write a concurring opinion going kind of like whole hog on this. And maybe that was the price of, getting the 6 votes was that Gorsuch gets the pen and, maybe that minimizes damages. If you look at what Justice Ginsburg has said about sex discrimination in the past, she should not have sided with Gorsuch in this case. In the amicus brief that I filed on this case, I point out that Ginsburg said sex discrimination requires double standards. It's when you hold women to one standard that you don't hold men to. But this was the same standard for all men and women, right? No one can cross-dress at work, whether you're male or female. Men can't be wearing dresses. Women can't be wearing coats and ties. The case involved a funeral home director, right? And there was a dress code here. So it wasn't as if there was a standard that men were exposed to, but women weren't, or women were exposed to, but men weren't. What was at stake here was that there was a man who wanted to present as a woman. And so that's not an instance of sex discrimination. But what we've seen here is that this isn't actually about the law. This is about a policy outcome. And so there were 6 justices who wanted a certain policy outcome.
Well, all of this is deeply disturbing stuff, and I'm glad that you're here to walk us through it. Ryan Anderson of the Heritage Foundation. Check out his book, When Harry Became Sally, Responding to the Transgender Moment. Ryan, thanks so much for your time. Really appreciate it.
Yep, thank you.
I hope you enjoyed that clip from the Ben Shapiro Show. If you did, go ahead and hit the subscribe button so you stay up to date on all of our future content.